Good day. Once again, it's Neil Gendreau, your money doctor, and today's podcast is going to be about estate planning. To begin with, just generally speaking, I mean, one of the most common problems that I face with clients is that most people tend to put things off. Many people eventually do financial planning. It comes out of necessity. But, the first step, people look at things in parts. I think everyone first is worried about accumulating enough money. And then they worry about, well, gee, I get this money. What about the income taxes I have to pay currently in the future, depending upon how all of that is invested? These are all valid concerns. But my point is that people's vision typically matches or expands the sense of urgency that's involved. So if it's not urgent, they don't think about it. But once it becomes more urgent, suddenly it's something to think about and something to do. But the problem with estate planning in particular is the further into the future, the more abstract it becomes. And also people get a sense of finality with estate planning because it often has to do with the distribution of assets at death. Not only do people not want to think about it, but sometimes they don't really have a clear picture of the future. However, people should, begin estate planning as soon as they do financial planning. Of course, the process evolves over time. So as your financial situation evolves, so will your estate planning. But on the other hand, people shouldn't wait until they're wealthy to consider estate planning any more than they should wait to become old before considering their own retirement. I mean, does that make sense? At some point, a threshold is reached and people begin to wonder, well, what happens to my money if something happens to me? And this is what estate planning is all about. And regardless, it should never be ignored. In fact, estate planning is one of the 6 key areas of financial planning. And although I'm not an attorney, my role as a certified financial planner requires me to acknowledge it and bring awareness about the subject to my clients. So, like I said, estate planning evolves with the complexity of your finances and also your goals, but it can become quite a rabbit hole. There's a lot of things to think about in that regard. And that's what elder law and estate planning attorneys are for. Since I'm not a licensed attorney, I refer this work to them. However, given my experience in dealing with clients like you, I am familiar with many of these concepts, and so I'd like to share them with you. So let's start with, what does estate planning accomplish? What are the major goals? Obviously, it's to make sure that assets pass to intended individuals, and possibly entities like charities, etc. Whether while alive you can do estate planning and make transfers too. By default, once you're gone, any remaining assets will eventually pass to someone after your death. But what we want to do is we want to execute these estate transfers in a well thought out manner with the least amount of cost and hassle involved. We want to be able to ensure that third parties can execute your estate administration on your behalf, and to ensure that similar third parties, or maybe the same third parties, can act on your behalf if you're incapacitated. So estate planning has living benefits too. It basically covers the basis of, well, what if I can't manage my own money? What if I'm sick? What if I'm in a hospital? What about medical cost? So it looks at all these different angles and helps you to come up with a comprehensive plan. Also, if estate taxes might be involved, to be able to reduce those estate taxes whenever applicable. Another very important aspect to consider is protecting assets from possible cost associated with long-term medical planning or long-term medical care. So obviously this is another angle. People are worried about getting sick and incurring costs such as assisted living or skilled nursing care provided at home or at some facility. How do you pay for all that? And how do you protect assets from not having to pay any more than what's necessary? Also, a good estate plan, if you have charitable inclinations, you can make charitable donations that not only benefit other people, but they benefit you while you're still alive. And we'll talk about that briefly in a moment. Another important feature is to be able to protect assets from creditors and other claimants. So estate planning encompasses all these different areas that I just mentioned. Most importantly is to make sure you can pass your assets to intended individuals, either while alive or after death. A lot of times people think, well, what good is giving away assets if either I or my heirs can't appreciate them while either of us are still alive? And that's why lifetime giving is a possibly important consideration. A lot of people like to be able to help their families out, especially children, to be able to prepare them for transitions of life, graduating from school, buying a home, helping us, just generally speaking, and to be able to give assets to anyone that you care about. The federal government allows an annual gift tax exclusion of up to $19,000 per year per person that you give money to. Now, this is kind of a moot point, but the reason why that's done is because normally, if you were to give more than $19,000 to somebody, you'd have to file a gift tax form, which is Form 709 of the Federal Income Tax Code. But what really happens is that the assets that you give away while alive reduce what's called a unified credit, which is the maximum amount of assets that be given to any individual while living or after death. So for federal tax purposes, you get a lifetime exclusion of $15 million based on 2026. So in actuality, this is not a problem for most people, at least not on a federal level, but it can be on a state level. And there are 38 states that don't have an estate tax, but there are also many states that do have their own special estate tax for their residents. At least in the state of Massachusetts, where many of my clients live, have a maximum annual lifetime exemption of only $2 million. So generally speaking, that's not very hard for most people to exceed over the course of their life. There's no annual gift exclusion in Massachusetts. There's no forms to be able to fill out when you make a gift, whether or not it's over $19,000. But the lifetime gifts that you do make are added back to the estate when you do the Massachusetts estate tax return. And of that $2 million, it's not probate, it's not portable between spouses. And what that means is that unlike the federal estate tax, where you have the $15 million exemption, after the first spouse's death, for instance, that person can use what's called the unlimited marital deduction to transfer their entire estate to the surviving spouse without any taxes anyway, even if it exceeds $15 million. And then the second spouse can take both spouses' unified credits upon the death of the second individual. That's not true in Massachusetts. In Massachusetts, if you don't make the most of your $2 million exclusion after your individual death, you can't transfer that benefit to your surviving spouse. So in order to do that, there are certain trusts that can be established to be able to hypothetically divide assets between spouses so that the maximum $2 million credit, as is the case in Massachusetts, can be used for both spouses. We'll get to that in a minute. But because most people aren't entirely interested in giving away all their money, wink, wink, most asset transfers come after death from the estate itself. And the easiest way to be able to transfer assets to a surviving beneficiary, especially if it's a financial asset, is with beneficiary designations. Quite simply, if you own, let's say, either a retirement plan at work or an IRA or a brokerage account or what have you, you can nominate beneficiaries on those accounts who would be in line to receive the remaining assets in the event of your death. It's called transfer upon death. And it's simply an operation of law that allows those assets remaining in your account to transfer to the beneficiary without probate. So the only thing that's required is a death certificate and demonstrating that death certificate to the entity where your assets are custodied, and then the ownership of that asset transfers from the original person to the beneficiary. So that's quite streamlined and simple. But there are problems with that we might, get into later. But that's just one method of doing it that's simple, but it's not always able to solve all the problems inherent within protecting your estate. Sometimes there are assets that you don't necessarily have a beneficiary designation on, which might include bank accounts, it might include some real estate. And any assets that don't have beneficiary designations or are not funded under a will must go through the court process known as probate. And that happens whether or not you have a will. So most people are familiar with what a will is, simply a way to nominate who gets your assets and possessions once you die. Well, even if you have that written on a piece of paper, it still has to go through probate. So some judge has to go through the will, read it, and then confirm or decide how those assets are to be divided up. Of course, because you're using the legal system, you're employing the government to help administer your estate, it's a much more time-consuming court process, even if the instructions are written in fine ink in the will, because it goes as a matter of public record. So in other words, the court has to publish the fact that there has been a death, that your estate is available, so that claimants, let's say if you have any remaining liens or liabilities that are outstanding that haven't been paid, those claimants can attach liens against the estate to recover what is due to them that you haven't paid off before you died. So in the will, you nominate an executor, and the executor is approved by the court, and then once the court decides exactly, once all the information becomes available to them, how the estate is to be distributed, the executor is the person who distributes the estate according to the court instructions. Okay? Now, obviously, there's a much better way to do that if you can't necessarily use a transfer of assets upon death designation, another method that also allows you to transfer assets without probate is what's called a living trust. And with a living trust, what that is a trust that's established by the donor, who now becomes the trustee of his or her own assets. So the donor is the one who appoints himself or herself as trustee. By law, the donor and now the trustee is still owner of all those assets. So the owner has the ability to direct those assets any way that he or she sees fit. Because, like I said, the trust is revocable. It can be changed. There's nothing that's locked into it. And it's essentially your assets until you die. And then once you die, that trust becomes irrevocable. Because now you're dead, you can't use your own assets anymore. So the only way that the assets can pass to another beneficiary is via the successor trustee, which is similar to the executor of a will, who you nominate to be able to direct the remaining assets to the beneficiaries at death. Okay? So that's a system that helps to avoid probate. Another caveat is that the revocable living trust, its conversion to an irrevocable trust upon your death, can be used as an estate tax reduction tool, which we'll discuss briefly. It's called a credit shelter trust. So we'll be talking about that shortly. Meanwhile, I was talking about charitable giving before, and although that, once you give away assets, obviously, those assets will no longer be in your estate. But the difference is that you're still giving away those assets while you're alive, but it reduces your taxable estate at death. There are different ways of doing this. There are two major methods. One is called a qualified charitable distribution, which is done from IRAs. And a qualified charitable distribution is something that's available to any IRA owner over the age of 70 and a half. And this is typically a very effective charitable deduction if you have such an inclination because the full amount of the charitable donation can be deducted up to $108,000 every year. Furthermore, normally any withdrawal from your IRA would be taxable, but because you're giving it to charity, that entire distribution is no longer subject to tax, once again up to $108,000, at least in 2026. It's set to adjust for inflation every year, like most IRA mandates. And what's just as well is that whatever you donate to charity from your IRA also qualifies as part of your required minimum distribution for that particular year if currently you're over age 73. So these are all tangible benefits that could be realized to help you save taxes if you have a charitable inclination. There's another fairly common method of charitable giving, which is known as charitable remainder trust. And what a charitable remainder trust does is it's designed as a way to take appreciated assets that you own, let's say a stock portfolio, that has a large amount of gains built into it that have never been taxed. It allows you to take that pile of money and convert it to a source of income while exempting the capital gains. So what happens is that while the donor is alive, that trust provides lifetime income for the donor. So it converts the capital gains inside the trust to an annualized income. And once the donor has passed, whatever is left goes to the charity. What's even better than avoiding the capital gains on the assets is that in the year of the donation, the donor gets an itemized tax deduction based upon the value of the gift, less the lifetime income stream that the trust is designed to pay out. The difference, though, of a charitable remainder trust from a charitable donation from an IRA is that the donor can only deduct a certain percentage of their adjusted gross income from the donation. If they donate cash, which is not really likely, they can deduct up to 60% of their adjusted gross income that particular tax year. More commonly, if the trust is funded with capital gains assets, then the donor can deduct up to 30% of the annual adjusted gross income in that particular tax year. Now, let's say if the present value of that deduction of, let's say, a stock portfolio, if it does exceed 30% of your assets in the year of the donation, the remainder of that can be carried forward for up to 5 years. So it does give you some fairly good likelihood that eventually you'll be able to take the whole deduction that's available to you. But of course, this requires some planning. And this is why, it should be coordinated with a licensed attorney. Now, there's another type of charitable trust that's kind of like the opposite of the charitable remainder trust. It's called the charitable lead trust. In a charitable lead trust, the charity gets, instead of the corpus or the principal at your death, they get the income and the asset remains in your estate. So it's kind of a backwards way of doing it. And it doesn't give you anywhere near the same effect of the charitable deduction, a way of removing money from your estate. And you don't get income out of it because that goes to the charity. But you're able to take an itemized deduction for the income that is paid to the charity. Once again, subject to those limits. So these are all very sophisticated tools and techniques. And of course, a lot of people don't think about it because they don't even know, in many cases, that they can do something like that. So like any of these different strategies I'm discussing with you, that's why it requires someone like me to first point out that if you do have any such inclination, these or a combination of these strategies are the ones that might tend to work, and then refer you to an attorney to be able to help execute them. And another potential problem, as I mentioned before, is it's more common that people will want to protect their residual estate or their existing estate from either taxes or probate or whatever the problem is. But in the case of estate taxes, we already talked about the fact that the federal government allows each individual to exempt up to $15 million of their estate, lifetime or after death. And this is in excess of charitable contributions or donations, all right? And that's portable, so it goes effectively to both spouses. But in many states, in fact, 12 states, including the state of Massachusetts, most of these states being the blue states, the tax collecting states, have an estate tax. And in Massachusetts, that threshold is only $2 million per individual, and it can't be deducted. I mean, it can't be transferred to the remaining spouse if it's not deducted from the estate originally upon the first spouse's death. So, as I was mentioning before with the living trust, it also becomes helpful for those families, let's say in Massachusetts, who have an estate value of more than $4 million to strategically split those assets as effectively as possible into two separate trusts, each containing at least $2 million of assets. Because what will happen is that at the death of the first spouse, that first spouse will be able to exempt their $2 million exemption. There'll be no estate taxes on the first $2 million, only in the excess of $2 million of assets that are theirs. And once those assets become sheltered from the exemption, or from the taxes because of the exemption, rather, that's what helps to create the credit shelter trust. And the magic is that the second spouse still has his or her assets, along with an appreciating estate, but all the assets inside the deceased spouse's credit shelter trust can appreciate indefinitely without any further estate tax. So it allows you to maximize both exemptions that way. Furthermore, the surviving spouse is eligible to receive up to 5% of the corpus of the trust each year as income, or any amount that is necessary for their general health, welfare, or well-being. So it doesn't really take away that much from liquidity or spending needs once an estate is at large, where they can still rely on their assets, plus a little dip from the credit shelter trust of the deceased spouse. The credit shelter trust has an independent trustee who's nominated by the first spouse to act on behalf of him or her at his or her death for the benefit of the surviving spouse. And then after the second spouse is gone, the second spouse uses his or her credit shelter trust that is exempted from $2 million of taxes, and the remainder of that estate, in both cases, is distributed by the successor trustees of each trust to the surviving beneficiaries. Now, placing IRAs or qualified plans generally into a trust is a more difficult execution than other assets. And the reason is first off, you cannot transfer an IRA into any type of trust while alive because it will trigger immediate income tax on the full balance that's transferred. That's something that most people don't want to do. However, at the owner's death, that IRA or 401k or company retirement plan can be transferred to the credit shelter trust of the deceased spouse, via beneficiary designation or will, better with a beneficiary designation. And then the surviving spouse can gain access to the income that's generated by that trust, and the trust is required to distribute the income annually based upon the beneficiary rules that apply. If the beneficiary is the surviving spouse, then the surviving spouse can take distributions from that IRA inside the trust over their remaining life expectancy. If the beneficiaries of the trust are children or some other entity or individual, that income has to be paid over 10 years. Normally, if there wasn't specific beneficiaries designated within the trust would have to distribute that IRA income over a 5-year period. So my point is, here again, this is getting very technical, but you can also maintain the IRA deferral benefits after the death of an individual owner, much like you could if it wasn't into a trust. It doesn't sacrifice those income tax benefits that are still available to each beneficiary. But if you put it into a trust while you're alive, that's a mistake. That will cause immediate taxes. And if the trust doesn't name specific beneficiaries, which is referred to as a look-through trust, then you also lose those deferral benefits, and it's taxed over a period of 5 years. This is why we need attorneys, okay? I can explain it because I understand it, but I can't draft it for you. So the attorney needs to draft the trust so that it has the specific language that qualifies the trust under these rules. Another very important consideration for many people is to protect assets in the event that their health might deteriorate and require long-term medical care, such as whether it's a visiting nurse or worst case, a nursing home. As people typically know, nursing homes are very expensive. Most people don't want to need one, but it does happen. So some of the preventative measures that are available to protect assets is possibly to buy long-term care insurance, but not everyone can medically qualify. So if you have a pre-existing condition or an illness that gives you the propensity of requiring care in the future, you're either going to have to pay an even higher insurance rate, or you may not get the coverage at all. Long-term care insurance, regardless of your health, is always expensive, and it's subject to increasing premiums if the insurance company finds that its premium estimate that it quoted you to buy the policy doesn't match the future payouts that it might have to pay to those who make claims. So long-term care insurance, it's kind of a sketchy option. It's expensive. Most people don't want to spend the money, which is why I generally encourage people to be able to become financially independent to the point where, worst case scenario, if some medical event like that happened, they could self-pay. In other words, my goal in working with clients is to make them filthy, stinking, rotten rich, where this isn't so much of an issue, but sometimes it can be. If you got enough money to pay for it, like if you have an estate of $4 or $5 million, much of which is financial assets, most nursing costs are temporary. They might last a few years on the outset. And even though it might make a small dent into your estate, it's not devastating. But getting insurance and paying for it typically is. In absence of that, there are many types of assets that you might be able to protect by gifting into what's known as an irrevocable Medicaid trust. And this is the type of trust that if you don't need the money, you don't need the asset, and you're concerned that it might be consumed by medical costs in the future, you can make a permanent gift that removes the asset from your estate and places it into a trust that is irrevocable, which means you give the money away, you don't have any further access to it. It's administered by an independent trustee, like most other irrevocable trusts. If you're a beneficiary, you might be able to get 5% of the annual income for health, education, maintenance, and welfare. But the biggest downside to this strategy is whatever's donated to the trust must pass a 5-year look back for Medicaid eligibility, which means that depending upon the size of the gift, it might take as long as 5 years to be exempted as what's called a countable asset. So that means, like, for instance, if you were to give $500,000 into such trust and the daily cost of care is, let's say, $500 a day, it would take you roughly almost 3 years for that gift to be exempted, which is calculated by the value of the gift divided by the daily cost of care. Okay? Could be as much as 5 years if the gift is larger, let's say $500,000. But so you have to wait for that period of time before the assets are no longer includable for estate recovery by the nursing facility. And worse is that if you put, once again, an IRA into this trust, it's never a good idea because it triggers immediate income taxation. So typically the best type of asset to give into this trust is real estate, which means that in this case, what you get is a life estate, which means you have a lifetime entitlement to live in and enjoy the property. But at your death, once again, it becomes ineligible as an asset that be claimed by a nursing facility against your estate. They can never take away your home when you're alive, regardless of whether you're receiving care. So it would have to wait until your death. The life estate eliminates that. The size of the gift is based upon the value of the real estate, but it's discounted by your life expectancy. So in other words, it's the present value, because eventually it's assumed that you're going to die, and the majority of the estate, the home value, will transfer. But there's still a small part that's included in your estate while you're alive, and that determines the value of the gift. Anyway, if that wasn't a mouthful for you, I understand if it was. And so, like I was saying, all this, and regardless of thinking about these different potential aspects, these different risks that you want to think about, not only thinking about the individual risk, but what you should do about them, it's a potentially complex process, and that complexity is magnified by the size of your estate on these. It's also magnified by your family situation, who you have in mind as far as beneficiaries, who inherits it. If you have dependents with disabilities or lifetime needs that need to be attended to. It also becomes even more complicated if you own a business, whether or not you want to see that business continue after your death, who inherits that, who manages it, what special privileges are available to reduce an estate size and make gifts for business owners. There are so many things that we haven't even talked about that will vary from one family to the next that should be considered. And that's why I'm here, is to let you know that I can identify these problems, that I can explain them to you, and explain what the potential remedies are. But in terms of making those decisions, we should also seek guidance from a licensed, experienced estate planning or elder law attorney to be able to devise an estate plan, to draw it up, and to bring it to life, to bring it to fruition for you. Also, once you have an estate plan, it's something that you should review regularly, just like your financial plan as a whole, as your personal, financial, or family situation changes. So my role as a CFP can help you identify these important areas and to coordinate strategies with the attorney of your choice. And my participation is crucial, so I can actually, on my end, help you to implement what's necessary. And also, I can work with attorneys that I've been in contact with, who I know do a great job for my clients. I can refer you to these same attorneys if you need one, and that will enable you to work in confidence with having your plan developed and executed as effectively as possible. So, hopefully this conversation has been helpful for you. If you'd like to be able to help others through exposure to this video, please be sure to comment, like, and subscribe to it. And of course, contact me with any questions. My information appears below. Neil Gendreau, the Money Doctor, and I wish you well. Signing off. Neil Gendreau, and these videos are not intended to provide specific investment or financial advice. Please contact your own financial advisor if you have one, or if you don't, why not contact Neil?